I turn now to your age and health. Your age is a significant factor in my sentencing exercise. As I've indicated before, you're now in your late 70s. It is relevant in a number of ways. Of some real importance in my sentencing exercise is the fact that each year you spend in custody will represent a substantial portion of your remaining life expectancy. While it is a matter of speculation as to how long you will live, the fact is that you are of advanced years and are entering the last phase of your life. Like anyone in the late 70s, your health will decline in time. I am conscious that the term of imprisonment, which I am about to impose upon you, carries with it a real, as distinct from theoretical, possibility that you may not live to be released from prison. Facing jail at your age in these circumstances must be an awful state of affairs for you. You are also clearly someone with some significant enough health issues. Your health is also a relevant factor, and it's related to your age. You have a significant history of cardiac problems and currently suffer from hypertension and congestive heart failure. You have a dual-chamber pacemaker. While stable out of custody, it is the opinion of one of your treating doctors that stress is an aggravator to heart failure if your blood pressure is not controlled. Your doctor has also observed that your blood pressure has been more difficult to control with stress. You also have osteoarthritis in both knees, and recently I granted you bail to undergo bilateral knee surgery. Your age and health also interacts with a number of other factors which I must consider, including the quality of your time in custody and your risk of reoffending. As to the former, one might anticipate the quality of your health will decline over time. The medical evidence does indicate that your heart and blood pressure conditions will be aggravated by stress. I have no doubt that you will experience some stress while in custody. I will make allowance for these matters. I turn now to the question of delay. The delay in your case since the offending is in the order of 22 or so years. The lapse of time since the commission of offences of this kind is, however, not unusual. It is often the case with offending such as yours that the victims do not come forward for many years after the offending. That all said, the delay in this case does have some consequences. As I've already observed, you now fall to be sentenced to a not insubstantial term of imprisonment as a 77-year-old man, and I've already touched upon what follows from this. The delay also means that you've been able to demonstrate the capacity to lead an otherwise blameless life in the 22 years since the offending, which, as I said, I will take into account. I turn now to consider your risk of reoffending, your rehabilitation, and to the purposes of specific deterrence and community protection from you. Cardinal Pell, I am satisfied that you effectively do not present as a risk of reoffending for a number of reasons. Your advanced years, the fact that you will be older still once released from prison, your otherwise good character, the fact that you have not offended in the 22 or so intervening years. Other factors, such as your notoriety and sexual offender registration, which I will come to, are also likely to further limit any interaction with children in the future and effectively eliminate any opportunities to offend. The prosecution has submitted that as you have shown no remorse or insight into your offending, there remains no explanation for your offending and the underlying causes cannot be addressed. The prosecution contends, therefore, that there remains a risk of reoffending, albeit a limited one. I do not accept that submission. The lengthy period without offending since these matters supports my conclusion that you have effectively reformed. And as I have said, there are other matters, such as your advanced years, which persuade me that you are not a risk to the community. It also follows that my sentence today is not aimed at protecting the community from you as an individual. In my view, specific deterrence also has no role to play. I turn now to the question of extracurricular punishment. It was submitted on your behalf that you have experienced an unprecedented level of public scorn and criticism. This is partly as a result of the investigation and prosecution of these offences, but such public criticism and scorn is also attributable to other alleged offences for which you were either not charged or where the charges were subsequently dismissed. It was also submitted that you have had to endure the stress of having to plan and work with your defence team on rebutting many charges that did not ultimately proceed to trial, and that you have lived under that additional stress for a number of years. It was also submitted that you have had to endure protests and verbal abuse whenever you were seen arriving or departing from court, at least during your preliminary court appearances, and that you have been publicly pilloried, both in the media and through the publication of a particular book. Finally, it was submitted that because of this kind of publicity and stigma, the resumption of your earlier career, including but not limited to... I'll start that again. Finally, it was submitted that because of this kind of publicity and stigma, the resumption of your earlier life, including but not limited to your career, is now impossible. Your counsel submitted that this material, at least looked at globally, represents extracurrial punishment. That is, a form of punishment that you have received over and above the punishment which I will impose upon you today through my sentence. Further, it was submitted that I should take this all into consideration when sentencing. The prosecution conceded that this is an unusual case, indeed a unique case, and have conceded that the matters relied upon by the defence warrant a level of mitigation. While the manner and extent to which extracurrial punishment and public opprobrium should be taken into account by way of mitigation is not entirely settled, I accept the position of the parties and your counsel's submissions in particular that I should make allowance for these matters in my sentence, and I have done so. I turn now to the question of your likely experience in custody. Your counsel submitted that life in prison for you will be more onerous than for other prisoners in the general population, and indeed other sexual offenders, because of your notoriety and the animosity to which you are likely to be exposed. The prosecution accepts that initially your experience of custody will be more burdensome than that of other prisoners. The prosecution went on to contend, however, that your future custody classification and conditions are unknown and are therefore speculative. The prosecution relies upon the affidavit deposed to by the Assistant Commissioner of the Sentence Management Unit of Corrections Victoria on the 8th of March 2019. The Assistant Commissioner in that affidavit outlines the current conditions experienced by you in custody and also the possible future conditions for someone who is classified as a high-profile prisoner who has been given protection status where there are significant security concerns. The affidavit also highlights that the conditions of persons with protection status at various different prisons are no longer significantly more restricted than those within the mainstream prison populations. Having considered all these matters, I do not accept the Crown's submission that your experience in prison after sentence is speculative. Even making full allowance for the fact that the experience of protected prisoners today is less restrictive than in the past, I need to make some predictive assessment concerning your likely personal experience. Like so many other things to do with your case, I think that your situation, Cardinal Pell, is somewhat unique. As the affidavit highlights, there are concerns about your notoriety and the extremely high-profile nature of your case. This gives rise to security and safety concerns. The Assistant Commissioner can say no more than that the safety risk towards you, currently assessed as at immediate risk of serious threat, may be reduced in protection so that in time you may be able to mix with a limited number of heavily fettered prisoners. I emphasise the use of the term may. I am satisfied on the balance of probabilities, however, that even with the best will in the world, your time in prison will be materially and negatively impacted upon because of these issues. Your position is not improved because of your advanced years and the vulnerability which goes with that. I accept your counsel's argument that I should give weight to these considerations. I will make allowance for these matters in my sentence. In a further supplementary submission, your counsel objected to the broadcast of these sentencing remarks. The complaint is that my remarks are broadcast live. I'll start that again. The complaint is not that my remarks are broadcast live, but that they are to be broadcast at all and may therefore subsequently remain on the internet. The defence submitted that if I chose to proceed with the broadcast, I should take this into account as further extracurricular punishment. I should also consider that this will further adversely affect your experience in custody, according to the argument. The essence of the complaint is that the broadcast of a robed judge delivering sentence will have a potency significantly greater than the publication of the written word. This constitutes additional punishment and opprobrium, according to the defence submission. I do not accept these submissions for the following reasons. The plea hearing was conducted in open court and reported on in full. Since that time, there has already been saturation, indeed febrile, publicity concerning you and these convictions on an unprecedented scale. These sentencing remarks would, in any event, have always been delivered orally in open court and would have been reported upon by the media without restriction. They would have been and will be published in written form without restriction. I consider that even if my sentencing remarks were delivered orally in open court and published in writing, the public would still be inundated with reports of my sentencing remarks and findings. Delivered in that way, the sentencing remarks would still carry the full weight of my judicial authority, as they should. Further, the media coverage of them would have been, in any event, at saturation levels. The broadcast of these sentencing remarks, therefore, does not communicate anything of substance more than what I would have communicated or delivered had I delivered them orally in open court and published them in writing. As the publicity will already be at saturation levels, I fail to see how the fact of the broadcast of my remarks will materially change the levels of coverage. On that basis, I do not consider that the broadcast per se will have any material impact on the levels of publicity and your experience in custody over and above the publication of my written sentencing remarks. Even if it is the case that a visual broadcast of my sentence is imbued with further judicial authority, this cannot be a legitimate basis for objection. It entails no punishment. The argument advanced by your counsel with respect, in my view, is irrational. The broadcast of my sentencing remarks is simply a clear demonstration of transparent and open justice and an accessible communication of the work of the court to the community in relation to a case of interest. I conclude by saying that the broadcast does not constitute additional or extracurricular punishment. Irrespective of the means of the delivery of my sentencing remarks, I nevertheless accept that your ongoing notoriety will continue to be exacerbated by the deluge in publicity which will follow my sentence. I accept that this will impact upon your experience in custody, as I have discussed, and I will take that into account. I now turn to consider the purposes of general deterrence, just punishment and denunciation. It was put by your counsel that the court should consider the unplanned, spontaneous nature of your offending and the fact that it was entirely out of character when determining what weight should be given to general deterrence. It was argued that general deterrence is of limited value to would-be child sexual offenders in the community who offend without premeditation, that is, spontaneously or on the spur of the moment. That is especially so where the offender acted irrationally without reasoned reflection, so the argument goes. I reject the proposition that general deterrence should be moderated in your case. There may be scenarios known to the law where general deterrence should be moderated. Two such scenarios have arisen in the course of argument, but neither applies to you. I will now deal with each of them. First, with some non-intentional offences, such as negligently causing serious injury, general deterrence will not loom large. That is because it would be, and I quote from a Court of Appeal judgment here, unrealistic to think that the sentence to be imposed would have the slightest effect on the likelihood of similar offences being committed in the future. Close quote. By contrast, the offences you, Cardinal Pell, have committed were each intentional offences. So this scenario does not apply to you. As a matter of logic, it does not follow that because sexual offending is out of character, spontaneous or unplanned, an offender is less deterrable. Potential offenders in that category have a capacity to weigh up, in a rational manner, the advantages and disadvantages of engaging in such conduct, even if this consideration is momentary. The message which the courts send to would-be child sexual offenders must be unequivocal. They must be dissuaded whether the offending is planned or whether it is the result of a spur-of-the-moment decision. The second scenario where general deterrence will be of less relevance in sentencing is where an offender has some form of mental impairment. That principle is founded on the basis that similar would-be offenders in the community whose mental impairment may limit their capacity to reason or to think rationally are less capable of being deterred. That scenario also does not apply to your case, Cardinal Pell. You, Cardinal Pell, did have the capacity to reason and to reflect upon your actions. Indeed, as I've already stated, I positively find that you did reflect upon your actions. The principles of verdance have not been engaged by your counsel's submissions. In supplementary written submissions, your counsel highlighted that sentencing courts have always drawn some distinction between a planned as compared with a spontaneous offence. I accept this proposition is correct. I stress that this is relevant to my assessment of the objective seriousness of the offending and in determining your moral culpability. I will weigh this into my consideration. I do, however, reject the notion that it diminishes the need for general deterrence. Now, having rejected the submission that general deterrence should be moderated, I now want to say something more generally about the role which general deterrence, denunciation and just punishment play in this sentence. The many factors I have identified in your favour, in particular your old age, your otherwise blameless life and the 22-year delay, must be balanced against the need for the sentence to properly reflect the purposes of general deterrence, denunciation and just punishment. Those purposes loom large when I come to consider your sentence. The purposes of general deterrence, denunciation and just punishment are very important in cases involving sexual offences against children. As the High Court has said, and I quote, "Sexual abuse of children by those in authority over them has been revealed as a most serious blight on society." Close quote. The sentence I impose must aim to discourage potential offenders by demonstrating to those offenders the grave consequences of violating such laws. Further, it is important that the factors particular to you do not devalue my assessment of the gravity of your offending and do not result in an inappropriately low sentence. I turn now to consider the maximum penalties and to the question of sentencing practices. In relation to the charges of indecent act with or in the presence of a child under 16 years, the maximum penalty is 10 years imprisonment. In relation to the charge of sexual penetration with a child under 16 years, In relation to the charge of sexual penetration with a child under 16 years, at the time you committed that offence, the maximum penalty was also 10 years imprisonment. While Parliament has since increased the maximum penalty for this offence to 15 years, it is the lower maximum penalty of 10 years which applies to you. The maximum penalty is not the determinative factor of my sentence, nor is the maximum penalty the starting point for my sentencing exercise. The maximum penalty is one factor of a range of factors that Parliament has prescribed that I must have regard to. In sentencing you, I am required to have regard to current sentencing practices. The relevant practices are those currently applied, rather than those applied by the courts at the time of your offending. The principle of equal justice requires, however, that I also take into account sentencing practices at the time of your offending, if they are ascertainable, on the basis that those practices are relevant to arriving at a sentence that is just in all the circumstances. Your counsel provided me with supplementary written submissions advising me that there were no materials, cases or otherwise to indicate with any precision what these sentencing practices were in the late 1990s. Your counsel did provide some material from the intervening years to support the proposition that the sentencing practices were lower then than they are today. The prosecution also provided supplementary materials, including some sample sentences and some statistics. I think it is fair to say that both parties accepted that there is very limited material as to past sentencing practices. It seems that both parties also accept that there are no truly comparable or contemporary cases for this offending. I can only gain the broadest of assistance from what has been provided by the parties. I am prepared to act upon the proposition, especially emphasised by your counsel, that sentencing practices for those offences were lower at the time of your offending. That all said, I also take into account that there is now a much greater understanding of the impact of sexual offending on child victims, and that this must be reflected in my sentence. As recently stated by the Victorian Court of Appeal, and I quote, "In approaching the sentencing task, the court may bring to bear its present understanding of the devastating impact that offending of this kind has, even though such an understanding may not have been a feature of sentences imposed at the time of the relevant offending occurred." Close quote. In any event, current sentencing practices are but one factor to be considered and are not the controlling factor of the sentence I must impose on you. Still less are past sentencing patterns the controlling factor for my sentence. I turn to another matter. Cardinal Pell, as I will be sentencing you to a term of imprisonment in relation to charges 1 and 2, you fall to be sentenced as a serious sexual offender in relation to charges 3, 4 and 5. I will note this in the records of the court. When sentencing you as a serious sexual offender, I must have regard to the protection of the community from you as a principal purpose for which your sentence is imposed when I'm determining the length of the sentence. I have, however, found that you do not currently pose a risk to the community. Further, the prosecution has not supported a disproportionate sentence and I will not be imposing one. As a consequence of my sentence today, you must also be registered as a sexual offender. By virtue of you committing these offences, your reporting period as a registered sex offender is for life. The prosecution made an application to obtain a forensic sample from you. Your counsel indicated that you consented to this forensic sample order being made. I therefore granted the prosecution application. I direct that you undergo a forensic procedure for the taking of an intimate sample. I'm further required to tell you that police officers may use reasonable force to enable the procedure to be conducted to obtain a sample from you. I now turn to the issues of cumulation and to the principle of totality. The law provides that sentences are presumed to be served concurrently, that is, they are to be served at the same time in an overlapping way. They are served concurrently unless I otherwise make orders that parts of a sentence are to be served cumulatively. Cumulation is where I direct that part of one sentence be added on top of another sentence. The totality principle requires me to ensure that your overall sentence remains just and appropriate for the whole of your offending. Any orders for cumulation must be moderated to the extent necessary to give effect to the principle of totality. The presumption of concurrency is reversed in relation to the sentences I impose on charges 3, 4 and 5, where you are sentenced as a serious sexual offender. However, I stress that the principle of totality continues to apply. I will make the sentence on charge 2, being the sexual penetration offence against the victim J, the base sentence. This is because it is the most serious offence and will attract the longest term of imprisonment. Charges 1 to 4 all form part of a single episode. In order to reflect this, these sentences will be served substantially concurrently. That is, some cumulation is justified. Some meaningful cumulation of the sentence I impose with respect to the indecent act against R, being charge 1, is required to appropriately reflect the fact that there were 2 victims in this overall offending. Were I not to do this, R would become a meaningless statistic. The overall sentence must appropriately reflect that he too was offended against and harmed. I'm going to order some relatively modest cumulation of the sentence I impose on charge 3 involving the indecent act of your touching of J's genitals. While this is part of the same episode in which J was orally penetrated, I think this indecent act is a sufficiently serious and distinct activity to warrant some measure of cumulation. I think some cumulation of the sentence I imposed with respect to charge 4, where you masturbated yourself while touching J's genitals, to charge 3 is justified. I would limit it to a relatively small amount in recognition of the fact that it temporarily overlaps with charge 3. I will then finally make an order of some cumulation with respect to charge 5 being the second episode. This is needed to properly reflect the fact that this was an additional distinct occasion of offending, separated by time. I will moderate each component of the sentences which I will impose upon you in light of all of the matters favourable to you, including your age, health, good character and experience in custody. In particular, I will impose a shorter non-parole period than I otherwise would have been inclined to impose, in recognition in particular of your age, so as to increase the prospect of you living out the last part of your life in the community. Finally, sentencing is often simplistically portrayed by some in the public sphere as being an easy and uncomplicated task. From where I sit today, the exercise is far from an easy one, and it is certainly not simple. I am required to weigh all of the relevant matters in this case and then reach a conclusion as to a just and appropriate penalty that reflects all of the circumstances of your case, Cardinal Pell. It is not a mathematical exercise. This balancing exercise is inevitably unique to the specific facts and circumstances of your case. This is what individualised justice demands. As I have endeavoured to show above, some of these factors pull in a favour of a more lenient sentence, while others pull in favour of a harsher sentence. In your case, this complexity is exemplified by the fact that on the one hand, I must punish and denounce you for this appalling offending. Yet on the other hand, I am conscious of the heavy reality that I am about to sentence you, a man of advanced years, who has led an otherwise blameless life, to a significant period of imprisonment, which will account for a good portion of the balance of your life. Cardinal Pell, would you please stand? All things considered, I impose the following sentences upon you. On charge 1, being the indecent act against R, I convict and sentence you to 2 years and 6 months imprisonment. On charge 2, being the sexual penetration against J, I convict and sentence you to 4 years imprisonment. On charge 3, being the indecent act against J where you touched his genitals, I convict and sentence you to 2 years and 6 months imprisonment. On charge 4, being the indecent act against J where you touched your own genitals in the presence of J, I convict and sentence you to 15 months imprisonment. On charge 5, being the indecent act against J during the second episode, I convict and sentence you to 18 months imprisonment. I direct that the sentence of 4 years imposed on charge 2 is the base sentence. I further direct that 12 months of the sentence imposed on charge 1, 4 months of the sentence imposed on charge 3, 2 months of the sentence imposed on charge 4, and 6 months of the sentence imposed on charge 5 are to be served cumulatively upon charge 2 and upon each other. This means that I sentence you to a total effective sentence of 6 years imprisonment. I set a non-parole period of 3 years and 8 months. That means you will become eligible to apply for parole after serving this non-parole period. Your release on parole will be a matter entirely for the parole board. I declare the 14 days imprisonment you have already served in pre-sentence detention as time reckoned as already having been served upon the sentences that I have imposed. You can be seated. Thanks, Cardinal Pell.